to introduce our AIA LA Executive Director, Carlo.
Yes, hi, good afternoon, everybody. Thank you very much for sharing part of your afternoon with us. Before I introduce our speaker, I would like to point out to our COVID-19 resource page on our website. You have received the URL together with the confirmation email, but take a look at it. You might find very relevant information for your practice. As mentioned, today's speaker is Ryan Kohler, attorney at law with Collins Muir Stewart, LLP. Ryan is an attorney that works extensively in the architecture and engineering world on issues of employment, contracts, professional liability, and claim defense. He has worked extensively with design professionals and defended them in trials, arbitrations, and administrative hearings. He counsels clients to help minimize the risk of workplace claims through educating managers, informing principals of legal trends and changes to the law, drafting employee handbooks, providing harassment seminars, advising on terminations and discipline, and litigating employment law issues before the courts and administrative agencies. Ryan is a great friend of the chapter, and we really thank him for being with us today. Ryan, please take it away.
Thank you for that, Carlo. Well, thanks for joining me, everyone. I know it has been a trying few weeks and month or so since we've all been dealing with the isolation orders. And since that has begun, I've been fielding a lot of questions from clients about the impact of everything on their jobs and the workplace environment. So my goal is to go through a couple of the issues that people have to deal with. First and foremost is the new federal leave law that applies to everyone with 500 employees or less. Some options to deal with the crisis, including pay reductions, furloughs versus layoffs, and also how the new laws and the new realities interact with some of the existing regulations like the Americans with Disabilities Act and Fair Employment and Housing Act, and how you as employers have to kind of navigate all the old obligations in conjunction with the new reality. Then we're going to look at some of the compliance with isolation orders that exist, go over the relief available from the federal stimulus bill, and then kind of deal with some other issues that I have seen pop up from various employers since things have kind of gotten started. And then at the end of it all, we'll answer any questions. I apologize if you have questions in the middle of the presentation, but I just kind of found in giving these Zoom seminars, it's sometimes easier to move through to the end before handling questions. If this had been live, I would have said, just put your hand up anytime you got a question. But we'll just hold all the questions to the end, and hopefully I'll either be able to answer them for you, or you can touch base with me after the presentation. So first off, the Families First Coronavirus Response Act. So that was one of the first major bills that was passed by Congress, and it's not the smoothest or clearest of bills out there. There's basically two different major categories of protection that exist. The first is personal, I'll call this sort of personal sick leave, and in many ways, the right description for this leave is not so much sick leave as it is crisis leave, because the very first category that is eligible, where somebody can get 2 weeks, 80 hours of full pay at their regular rate, up to the caps that are listed here, $511 per day or $5,110 per employee, is if you're in quarantine or under an isolation order under state or local rules related to COVID-19. So if you can't come to work because of some sort of isolation order, you are eligible for 2 weeks of federal sick leave. The other two categories in here is related to sort of personal sickness issues. If you're advised by a healthcare provider to self-quarantine due to concerns, you don't need a diagnosis or anything like that. The law kind of recognizes that there is a critical shortage of tests, that people who go to hospitals cannot get tests frequently. So there is no sort of standard of proof where an employee has to come in and say, look, I've got a positive COVID test, I get my 2 weeks. It could just be, I've got a fever and I've got a cough and I've been told to self-isolate, and that's kind of it. So it's in many ways, there's not a huge amount of documentation. The What you would want is you'd want something from the employee in writing telling you that they are advised by a healthcare provider to self-quarantine, or that they are experiencing COVID-19 symptoms and trying to get a diagnosis, because you want to keep that type of information for applying for the tax credits that are related to this. So the way the federal government handled this is that they are requiring you, the employer, to kind of pay it up front, but you get to deduct everything that you pay under this act from your federal taxes. The second category is 80 hours at 2/3 of someone's regular rate, subject to the caps that are noted, if they are either caring for an individual that is subject to a quarantine order or that has been advised to self-quarantine, or if they're caring for their child, if their child's school or place of care is closed, or the child care provider is unavailable. So if they, you had a nanny, if you had a daycare type of thing, and suddenly that is shut off because of the COVID crisis and the person can't work, then they're allowed to take up to 80 hours for that. The law also has kind of a catch-all provision that says, or similar issues as defined later in coming regulations. And these regulations have been subject to some frequent updates. So there may be some further clarifications of this down the road, but right now, these are the main areas of eligibility for the federal sick leave under the Coronavirus Response Act. Additionally, this law also provided something very new, which is paid FMLA rights, so paid Family Medical Leave Act rights. Now, typically, FMLA is just for it's unpaid, and it just provides some protected leave when somebody's out. And it only applies to people with 50 or more employees. And so with this new law, you've got something that applies to all employers who employ less than 500 people. And it provides a paid FMLA period where you get 10 weeks paid at 2/3 salary, subject to the caps that are noted. And it's to basically take care of your kids. So if you have childcare needs created by school closings or by the childcare provider unavailability, and you're saying, well, I'd love to work from home, but I can't because I have to take care of my children, then you can get some paid FMLA leave for this. And the first 2 weeks of this FMLA period is unpaid, but you can use either your typical accrued vacation or sick leave benefits, or the federal sick leave that it was provided in this new law as well in that first 2-week period. So the 2 weeks and then the 10 weeks the FMLA provided in the law kind of work together. As noted, this is fully refundable through federal payroll tax credits. And so if you've got some sort of escrow account that you used for those payroll tax credits now, you feel free to raid that. Now, a very important point right here is that this type of leave is only available if the employee cannot work or telework. So if you've got somebody who is able to work from home and is subject to a quarantine order, then this does not apply. If you've got somebody who is experiencing some symptoms or even tested positive for COVID, but feels fine and is able to telework, then they are not eligible for this leave. Now, if you've got somebody who says, I feel terrible and I've got some of the symptoms of COVID and I don't feel up to working, I'm just going to lay in my bed and be feverish, then that person is absolutely eligible for them. But if you are in a situation where somebody is available to work, they're not eligible for this leave. One other minor thing to note is that the federal government also requires disclosure about these leave rights. There's a poster that's required. You have to put it up in your break room or other places where you typically post your wage and hour posters. Since people, for the most part, aren't going into work or they're encouraged not to go into work, this poster should be emailed out to all your employees who are working from home. One other thing about this leave law is that it expires at the end of the year. So it's a temporary thing. Come January 1st of 2021, there will be no federal sick leave. So it is a temporary measure just for the current crisis. There is also a new small business exception that has been promulgated in the regulation. So if you're under 50 employees, you can get out of providing this leave if you provide the following authorizations. Somebody that's an officer of the business has to certify that paid leave would basically put us out of business or substantially cripple our ability to operate. So if we give this leave to somebody, then our expenses are going to exceed revenue and we're going to cease operating at a middle capacity. Or if we grant the leave where it's substantial risk of closing, either because the people who are asking for leave are so critical to our job that they have special skills or knowledge, or we just have so limited number of workers, and if people leave, we won't be able to kind of keep our doors open or run at the minimal capacity. So if you're looking at these leave obligations and thinking, well, I don't know if we could do this, if we have too many people that ask for leave, maybe the whole business will fall apart, then you can get exemptions from it. But let's say there aren't any issues with leave and it's just a question of suddenly business has dried up, there's less work to be had. How do we handle things with the sort of big crunch that we're all looking at thanks to the stay-at-home orders? Well, there's a whole host of different options you can look at. Pay reductions, furloughs, layoffs, stimulus relief measures through the governments, or even just kind of other bank loans. And I'll kind of take a look at some of these options. So for pay reductions, California is the default situation is an at-will state. So that means if you want to change the employment terms and conditions for your employees, you're free to do that at any time. Just like your employees are free to say, you know what, I want a raise, and if I don't get it, I'm walking out the door. The only thing I have to caution is that if there's going to be any pay reductions, it needs to be prospective only. So if it's the middle of the pay week, don't start reducing somebody's salary or hours or rate of pay for time that they've already worked. It can only be going forward. And the tricky ones to work with are the exempt employees. So if there's people that you're paying on a salary and they are making above the exemption limit, and they're not, they also have the appropriate duties that put them in the exempt category. So they're either an executive, an administrative, or a managerial exemption. Then the law doesn't like it if you're just changing their rate of pay or changing their salary all the time due to outside economic conditions. The whole point of putting somebody on salary and claiming them to be exempt means that, I'm paying this person a flat rate and I'm not, necessarily caring how many hours they're working or what their billing is or anything like that. That is the type of considerations we look at for people that we pay hourly. So if you are handling an exempt person and you're cutting their pay, you want to the goal is to full salary when economic conditions permit. You're only supposed to make these changes when you experience significant economic difficulties. Now would qualify for that. If their pay falls below the California state exemption limit, which is 2 times state minimum wage, which is about $49,000, I believe, or right in that neighborhood, then they lose the exemption. You have to be paid at least that much to be exempt from minimum wage. That's one of the requirements. So if you have to cut somebody and they fall below that, just make them an hourly worker, basically. And the employer can't alter the salary so much that the salary basically becomes a sham. But if you keep your eye on that, you can reduce someone's salary going forward, and also let them know that you can, the goal is to get them back when things return to normal, if they return to normal. Just don't make any promises that are, ironclad. If you're guaranteed to be back to your normal salary in a month or something like that, because none of us know what the future holds at this point. Next options out there are layoffs versus furloughs. So a furlough is a temporary directive not to work. So you're telling an employee, don't come in this day, this week, these 3 weeks, or something like that. You still maintain somebody's benefits. You keep them formally registered as an employee. When I say maintain benefits, that means if they've got health benefits or other things that you, the employer, are paying, continue to do that. You can make the employee pay for the employee share, and that can mean them writing a check to cover like their health insurance or something like that to the company. But the benefits are maintained. You also want to make sure your furlough has a clear start and end date. If you're saying we're furloughing you, we have no idea when you're coming back, we'll give you a call. The state will say, nope, that's not a furlough, that's a layoff, and you'll be hit with penalties because when you lay someone off, you're required to pay them like their final wages, pay them out all their PTO and things of that nature. If you have an exempt employee, furloughs for them are tricky because if somebody's on salary and they do any work during the week, they're entitled to their weekly salary. So you could have a salaried employee and they work 1 hour on Monday and 30 minutes on Tuesday and really nothing else the rest of the week. You're still going to have to pay their salary. Now there's differences there if somebody takes some time off, but if you furlough somebody who's exempt, you have to give them strict orders not to work, and you got to kind of have to lock them out essentially of their email system because you don't want them getting on and checking and doing a little bit of work here and there. Frankly, it's easier with exempt employees to just say we're going to lower your salary unless it's clear you can give these type of furlough orders and that they're going to be able to follow it. If a furlough becomes excessive, then it can be deemed a layoff as well. There's no bright line on, well, a 3-week furlough is fine, but a 3.5-week furlough is not. Each thing is sort of case dependent. And my guess is that the state will be pretty flexible on how they are interpreting things based on the crisis, and they're going to be kind of soft on things. But if you give somebody a furlough for 2 weeks, and then you extend it another 2 weeks, and you keep on extending it 2 weeks and 2 weeks and 2 weeks, eventually it's going to be deemed a layoff. Employees who are furloughed are still entitled to unemployment benefits. So if you're communicating to your workforce that we're going to have to furlough some people, communicate that, hey, apply for unemployment immediately. Unemployment is there to both cover shortfalls in income. So even if you just reduce hours, it's available to some employees. And if you're furloughing them, it's absolutely available to them. So do encourage your employees to file with the state. Now, a layoff, that's termination. It's even if it's a short term of, hey, we're gonna have to let you go now, or we're not sure when we're gonna call you back, but we're gonna do it in a couple of weeks. That's our hope. That's still a layoff. So when somebody is laid off, you have to pay out all their wages owed at the time of termination. You have to pay out all their accrued PTO. You're not offering them any benefits. Now they can apply for COBRA, they can apply for unemployment, but you're pretty much ending the relationship, formal relationship between you two with a layoff. If you're uncertain about when or if you're gonna recall an employee, go ahead and just make it a layoff. That's what I would say. Now, you've still got obligations under the Americans with Disabilities Act and the Fair Employment and Housing Act. And so typically when people have illnesses or problems with work, there's supposed to be a big, complex, interactive process that goes on to try to find a reasonable accommodation. However, in this kind of crisis time, an employee that poses a direct threat to the workplace is not protected. So you don't have to engage in an interactive process or anything like that. If somebody comes in and they're coughing, or they look feverish, or you're like, hey, I've got some suspicion that this person might have COVID-19, send them home, get them out of there, and you don't have to worry about potential liability or discrimination claims because these people are potentially threats to themselves and to others. If you do send an employee home, however, after they report, and they are an hourly employee, so they show up in the morning ready to work, they are eligible for reporting time pay, which is usually about half of their shift. So when in doubt, pay them half of the day's pay, but still send them home. For the rest of it, with the American Disability Act and Fair Employment and Housing Act, the virus is generally pretty short-lived, unless somebody's in the hospital, in which case they're not going to be able to work. There's no real reasonable accommodation for them. So there's not a huge amount of telework or remote work or rather reasonable accommodation concerns with employees who get COVID. You either are sick and you feel terrible, or you're not. The only time that there might be some sort of reasonable accommodation window is like the 2 weeks after somebody's recovered, when they're still in quarantine. But just keep them in quarantine. That seems to be well accepted under the law. And if they're feeling better and they can do remote work, have them do remote work as a reasonable accommodation. Otherwise, we don't need to accommodate them by trying to find a way to get them into the office. When you learn of potential exposure in the workplace, you're supposed to maintain confidentiality. So don't tell your other employees, hey everyone, Bob had COVID-19. If other employees were potentially exposed though, you do want to disclose that to them so that they can do additional monitoring, potentially self-quarantine if there is any significant exposure, but just don't name the source. Now, if the circumstances are that you think, you know what, I tell employees they're going to figure out who has COVID. That's okay. It's okay if somebody puts on their detective hat and figures something out. So, you know, let's say two employees shared a car ride with each other and were in the same confined space for an hour, and you find out one of them tests positive for COVID. Well, you're going to tell the other one, yeah, you were in a car with somebody for an hour who tested positive for COVID. They're going to figure it out, but don't worry about that. So LA County guidelines say that exposure is being within 6 feet of someone for more than 10 minutes. So just because someone was exposed and, you know, potentially walked through a hallway or, you know, was briefly within somebody's area for a moment, that's not necessarily an exposure. But if you've got somebody who's in a car, in an office space, in a conference room with somebody who has COVID and tested positive for a significant amount of time, and what you're going to want to do in that scenario is to send that other person home if they are at the office or the job site, and have them self-quarantine for 2 weeks until they've cleared out. But just the random, you know, passing by, that's not so much. You may want to inform your employees that there's a potential exposure and they should do additional monitoring and vigilance, but you don't necessarily need to order them to self-quarantine. So that gets me to isolation orders that we're all working under. The state order has some pretty broad exemptions for our line of work. So construction workers who support the construction, operation, inspection, and maintenance of construction sites are exempted, as are professional services when necessary to assist in compliance with critical sector services. And construction is noted as a critical sector. So there's nothing in any of the state orders that specifically says architect. But combined with the construction worker exception and the professional services exception, I think it's pretty clear that architectural services are exempt and you can continue working. However, I would also note that all the state orders say try to work from home as much as possible. So if you can accommodate remote work, I would suggest you do that. I'd also note that there's no specific written note or other specific authorization from the state that is needed to work. The state has clarified that. So I do know some firms who have written letters kind of explaining why it is somebody is out and about and that they are exempt. I haven't seen any issues with the state having an issue with that, but some of the smaller cities sometimes have questioned people who are being out and about. So depending on where your location of your construction project is, you may or may not want to provide that type of note to your employee just for sort of peace of mind. But I would note that that type of note is not required under any of the state isolation orders. One of the other things that is required, that even if you are having somebody go into the office or go out in the field, they are still required to practice appropriate social distancing and appropriate hygiene efforts. So as kind of one of the Cal-OSHA safety obligation requirements out there, you should be doing or giving some additional trainings or notifications to your employees about making sure that they perform appropriate hygiene. I'd also suggest checking all the local county or city ordinances if they're outside of LA or working with any other city, because some areas are allowed to have more restrictive regulations than that issued by the state. Most of these also fully incorporate the state's exceptions. So for the most part, you should still expect to be accepted from the isolation and stay-at-home order as part of somebody working in a critical industry. That's enough about the isolation orders. My next topic is the Coronavirus Aid, Response, and Economic Security Act, which is called the CARES Act. Sometimes it's called the Federal Stimulus Bill. It does a wide host of things, one of which is it has increased unemployment coverage from 26 to 39 weeks. People who file are eligible for an additional $600 a week in federal unemployment benefits. And the state of California actually only gave out $450 a week. So that's a good benefit for people to have. That goes through July 31st, and then after that, it'll fall back down to the state level unless the feds bump up the funding. This is also available for reduced hours. So if you've got hourly workers who were 40 hours a week full-time and now are just working 10 hours a week or 5 hours a week or something like that, you should let them know that they are eligible for this federal unemployment and that they should apply. The CARES Act also provides benefits to more groups of people. So if you're self-employed and now suddenly your hours have dropped and you have very little money coming in, typically you were not able to apply for unemployment. Now you can. Same with part-time employees, same with gig workers or short-time employees. And it also applies to those who were, quote, required, unquote, to quit because of COVID. So a lot of people who were traditionally shut out of the unemployment insurance system, if you haven't applied and you've taken a hit in lost income, you should look at applying because you might be able to get something out of it. Another big one is the Payroll Protection Program. That's part of the stimulus bill. It's available through the Small Business Administration, and it's meant to cover payroll obligations and some other costs. And the biggest thing is that it's got a mechanism in it for loan forgiveness. So whoever hasn't applied for this, I suggest you apply. I've heard that the loans are currently at their limits in the sense that the amount of funds that have been allocated have all been spoken for, but I'm hopeful that a supplemental bill will get passed and some of this should get refunded and applications should be opened up. So this is done through your local banks and lending institutions. So if there's a bank that you have a relationship with and you haven't applied for the payroll protection program yet, I would highly recommend contacting your bank, speaking with them, and even if the funds are all depleted, find out what needs to be done, have the application filled out, ready to go at a moment's notice in case things get re-upped. If you already have applied, good. Payroll is for employees. That excludes independent contractors. So if you've got people that you've labeled as independent contractors, do not count them. You can count temporary employees, although the regulations for all that are still in the works. The forgiveness is more than just payroll. It includes payroll costs, interest payment on mortgage, covered rent obligations, and covered utility payments. Forgiveness can be reduced if you lay off employees, because the goal of this loan is to keep employees paid for the 8-week period after the issuance of the loan. So if there's a substantial number of employees who get laid off, then you're not going to get as much of this loan forgiven. You can get up to 100% of the loan forgiven too. So there's benefits in paying these people. Additionally, there is a cap on it. So there's a $100,000 cap per employee. If you reduce people's pay excessively by 25% or more, that's also going to reduce your forgiveness. And if the loan is not forgiven, or there's portions of the loan that are not forgiven, there's 1% interest on it. So even at the end of the day, it's not that bad of a loan. The $100,000 salary limit can be used for partners or owners, people who have guaranteed pay or draws. If you have employees who have a salary of under $100,000, there's some additional payments that you can add to that, like the employer's share of 401k, health pays, state and local taxes, but not federal, and like vacation time accrual. So try to cram as much as you can into that $100,000 cap. Another important thing is keep really good documentation. If you don't have good documentation, you're not going to get your loan forgiven. So keep everything that is relevant. You want to track payroll, verification of payments, accounts, statements, bills, anything that substantiates what you're paying out. So that's kind of the big picture of employment law. I wanted to talk about a couple of other considerations that exist as well. One of them is whistleblower protection. and retaliation claims. So those are kind of our standard employment law claims, which we see quite a bit of. And if there are employees who are concerned about safety or concerned about going on the job site, and they mention these concerns, and there's action that is taken against them, then you could suddenly find yourself liable for some sort of whistleblower action or retaliation claim. Additionally, under the National Labor Relations Act, and LRA, not NRLA, sorry about that, employees have a right to discuss and take part in concerted activity. So what that means is that if there's employees that are complaining amongst themselves about job site conditions or safety type issues, that if you take action against them, that is a violation of the National Labor Relations Act, sort of a cousin to sort of union organizing activities that are protected. But the NLRA is sometimes difficult to enforce, but what is easy to enforce is whistleblower retaliation claims in the state of California. So if somebody's out there and makes a claim of saying, hey, I spoke up about safety concerns and I was terminated shortly thereafter, that's not going to be a good look. So if you've got a situation where you've got employees that are like that, even if you're about to consider terminating them, I would recommend consulting with counsel a little bit to work through that and kind of set it up appropriately and make sure you've got appropriate documentation in place to justify your termination. When it comes to employment law claims, the kind of number one thing that happens is that a plaintiff's attorney is going to take a look at the employment file and personnel file of the employee to see if there are appropriate documentation of any issues before the termination. Now, we are in a way an easier time to terminate employees because all you can do is you can just point to economic activity and say, well, based on the economics, we had to terminate somebody. But if you, for example, received the paycheck protection loan, and so there was no reason to terminate somebody during that window because they were fully funded by a forgivable loan, then you won't be able to point to economic issues, for example. There's also safety guidelines that have been put out by Cal-OSHA. So as an employer, you are kind of obligated to make sure you're having a safe work environment. So the key considerations at this time are actively encourage people to stay home if they're sick, encourage people to stay home in general and work from home, send employees who have any sort of symptoms home immediately, and then perform environmental cleaning of shared workplaces. So the details of that are not that specific, but it just says, make sure it's disinfected in a sort of routine way. So, spray it and wipe it down is all you really need to be doing. You don't need to be pouring mountains of bleach on everything. The other parts of the safety guidelines recommend training on hand hygiene, avoiding close contact with people, avoiding the eyes, nose, and mouth, washing dishes. I've seen this in multiple recommendations, but I had no idea this is actually something that happened. Avoid sharing personal items with coworkers like cups, utensils, and towels. So all of you people out there sharing your towels with your coworker, I don't know who you are, stop that. And then, of course, providing tissues, trash cans, and hand sanitizer. And then, most of all, maintaining social distancing. Masks is a bit of a new one. So LA County and the city of Los Angeles now requires the use of masks in public. So that would include job sites and, traveling or walking on the streets or going to job sites. If your employees do not have masks, then you should look at issuing them masks. I would say that masks inside, like your own office, would not be required, but if you see employees that are wearing masks, like at reception desks, that actually probably would be a good spot. Areas that are open to the public should have masks, so a reception desk might qualify. And if you see employees wearing masks in the office, I wouldn't stop them from using it. So if somebody is more comfortable wearing a mask, let them wear a mask. I've seen situations also where employees will not work, saying, I'm still very concerned about what's going on the job site. So someone's concerned about safety have to be reasonable. And just saying, well, I know that there's a disease out there somewhere is not necessarily specific enough to be reasonable. There has to be somebody who's possibly exposed in the office or in their work environment, or they're going to work environment where people are not practicing all the safe measurements. But if you've got somebody who's just, you know, I know that the office is open back up, or I know that we're in an exempt industry, but I'm just not comfortable doing it. What do? Well, you can discipline them for failing to return to work. However, it's not a good look, even if it might be legal. So you might want to consider furloughs or unpaid leave of absences rather than jumping right on them with, you know, hey, this is your job. If you're not doing it, you know, that's unacceptable type of dropping the hammer on them right there. You have that option to do so, but I would recommend taking the softer approach, at least at first. And if somebody's, you know, being candid with you and saying, I can't do this work, then I think they'll probably have a pretty good understanding of being put on an unpaid leave of absence. One other issue I wanted to address is that when people are working from home, they are incurring expenses related to the business. And California Labor Code 2802 has some pretty strong reimbursement requirements for businesses. And there's a case out there that basically said if you were requiring people to work from home, even if this is an expense the person would have paid already, then the employer should be paying a share. So if everyone is logging online and doing virtual work from home, and it's mandated that they do so, then you might want to consider offering to reimburse them some portion of their internet fees. Now, the key here is mandatory. So if you say office is open, we're in an exempt industry, you can come into the office to get your work done. If you feel safer at home, you can work from the home office. As long as you've got the capabilities to do so, then that is the employee choosing to work from home. In that case, it's not a situation of potential reimbursement for their home office expenses. It's only if you're mandatory working from home that there is likely some sort of obligation. Now, the case in question on it, when it said, well, how do we figure this out? What's the proportion? It was overturning a ruling in favor of the employer. And so they just sent it back to the lower court and just said, how do you figure out how much to pay? That's a tough question. It depends on the case, depends on it's best to be left between the two parties. So my recommendation is if you just tell them, hey, you know, we feel like a reasonable amount to compensate you, you know, might be, if somebody's working 8 hours out of a 24-hour day, and it would be, you know, 40 hours worth of internet for a whatever, you know, the total hours of the work week is, or the total hours of the week. So that might be a reasonable sort of proportion of their internet reimbursement. So with that, I'm going to go ahead and open it up to questions. And Corinne, if you could take away the shared screen. Thank you.
Great. So if you guys would like to participate with questions, please either enter your question into the chat box or do the raised hand. And please don't be shy. We want to hear from you. And Will, you always have really great questions in between if you have one while people are thinking. All right, we have a question. Tina, do you want to see your question to the group? If so, you can unmute yourself, or I'll just say it out loud. Okay, I'm going to read Tina's question. She says, does the exemption apply to sub-consultants? We are lighting designers and not sure if we are considered exempt. We can do most of the work remotely.
So for the exemption, I would say yes. So the exemption from the isolation order, it's not so much of whether or not you can possibly do the work remotely. It is a question of if you are working in a particular industry or not. Now, the state Cal-OSHA guidelines, and I'll stress these are guidelines, these are not orders or requirements, say that if you can work from home, you are encouraged to do so, even if you are in an exempt industry. So the employers are encouraged to have people work from home as much as possible. However, as somebody that's involved in design, that's in construction, and construction is broadly exempt, well, my interpretation of the rules would say that you are exempt from the shelter-in-place order. I hope that answered the question. I've got a couple questions in the chat here. So if the salary is reduced, is the employee still eligible for $450 a week? Well, actually, the eligibility for unemployment insurance is now they get up to $1,050 a week, thanks to the extra $600 that the feds pay. And in essence, the question will be is whether or not the employee is making more or less than the unemployment level. So that unemployment insurance level, works out to about $48,000 or so, or really $50,000 a year. So if somebody's making more than $50,000 a year based on what they're getting paid now, they're probably going to be ineligible for unemployment. But if their hours are reduced below the 50K level, then they're able to get unemployment to kind of bridge the gap up to that $50,000 or so level. But since unemployment is processed by the state, it's sort of a question of if someone's not sure if they are or not eligible, just encourage them to go ahead and apply. Another thing about this whole crisis is that it's a rather dynamic situation. So, what is true today might not be true in a week or two when you field this question. So rather than you becoming a personal expert on how the state's managing the unemployment insurance program, just say, well, if you think you're in that neighborhood or below, go ahead and apply. Does the Family First Act apply to exempt employees? Yes, it does. So if somebody is a salaried employee and is exempt from the wage and hour laws, then the Family First Act and the leave laws would apply to them as well. For paycheck protection applying to a sole practitioner, I would say yes, there are measures within the Paycheck Protection Act that would allow somebody to protect their own paycheck up to the $100,000 level. And I know that there's a question that was a verbal question. Did I hear?
I don't think so, but I always like people to give them the option to speak up and to engage as well. So Michael Karp, would you like to address your question? People don't want to today. That's fine. Oh, there he is. How are you doing?
Oh, this is Marcos. It's not Michael.
Oh, Marcos. Marco, you came on screen, so we'll give it to you.
Okay. I was just curious, how many people have seen any money back from the PPP or the EIDL?
That one I don't know. I haven't been involved in our own firm's effort to get any loans, if any. So we've been advising people on the application process, but I haven't really gotten a lot of feedback from folks yet on the results of that. I know that initially banks were absolutely kind of overwhelmed and feeling a bit lost due to the lack of federal guidelines. Things have kind of trickled out over the last few weeks, and there's a bit more clarity from the banking side, at least when it comes to issuing the loans, but there still is a certain lack of clarity, I feel like, for the forgiveness.
Okay, let's go to the question from Michael.
Sure. So if you're working remotely and conducting business and payroll as if at the office, and someone says they feel too sick to work, they should be able to get sick time because they're still working and they're just saying, I do not feel well enough to sit on the computer and log on and get to work there. So the question says we pay for 1 week. What happens if it exceeds that? So the federal sick leave in the Family's First Coronavirus Response Act is in addition to the sick leave and PTO offered by employers under state law, or the optional vacation time that is offered. So if somebody burns through a week of state sick leave or sick leave that you just offer as part of your policy, and they're still going to have their 2 weeks of the Family First Coronavirus Response Act sickness, as long as the sickness is actually related to COVID. If it's, a statement of I've got, some other issue, my diabetes is acting up, or I slipped on a banana peel and I hurt my back and I can't work on my laptop, the Family First Coronavirus Response Act leave is not there to cover that. But if they contact you and tell you, I feel terrible, I've got a cough, I've got a fever, I don't feel well enough to work, then it would apply, and they would be able to take their Family First Coronavirus Response Act 80 hours.
So it's kind of on a similar note, there's a question from someone who didn't rename themselves, that's iPhone. If the office is open and an employee can't return because of certain unidentified health reasons, immune deficiency, can they work from home? Sorry, they can work from home, but it's at half power. How do you recommend dealing with them?
I would recommend, if they can only work at a half of the load, and so the amount of billing that they have is significantly impacted. And so let's say they were billing it, they were salary employed and they were typically billing maybe 40 to 45 hours a week, and now suddenly they're down to 20 just because of inefficiencies of working at home or inability to access certain systems, or even due to the crisis itself, then I would recommend lowering their salary and saying, right now there's not as much work that you can do. We're in a crisis situation, and based on that, we need to lower your salary to X. And if that X puts them below the salary exemption limit, then I would look at changing that into an hourly worker. And one thing I do want to note is if you've got people who are salaried and you're changing them to hourly workers, you do want to give them a bit of a briefing on what that means, about the need to get approval before they incur overtime, an obligation that they have on their own to take meal and rest breaks. And because they're working at home, they'll be expected to take all of these meal and rest breaks at the appropriate time, and will be assumed to do so unless they notify you otherwise. But that's likely the sort of best way to deal with somebody who is only at, as you said, half power.
And then the question above that, if exempt employees have already been reduced to 75% of their salaries, can you use the PPP to pay them the 75 level, or do they have to go back to the 100%?
Well, I know that for people under $100,000, you can still get full forgiveness if you do not reduce their salary more than 25%. So to me, that the implication there is that if their salary was reduced to 75%, you pay them at the 75% level, then that would still be fully eligible for forgiveness under the Paycheck and Protection Act. But I would say that this is something that is kind of constantly coming out, and new regulations are coming out on a daily basis. So I would double check with the bank that funded the loan to make sure that their underwriting or the forgiveness guidelines that they're receiving from the IRS match up with the latest kind of regulations and guidelines that I cited. Because it is sort of a moving target. I would definitely say when it comes to this, the forgiveness, not all of the laws and regulations have been written yet. So I would check up with my financial institution or my accountant on that to make sure that what was true yesterday is going to be true tomorrow.
Okay, and I think I'm going to keep reading the questions today just because I think a lot of them are sensitive, and if you want to take over as well. But we have one from Hank. Does the employer have to file for a work share for employee to get unemployment benefits for reduced salary?
No, they don't. So the work share program is interesting in concept, and if an employee or employer is suffering from lost revenues or a significant business downturn, they can work with the California Unemployment Insurance, the ED, to kind of develop a plan to reduce people's hours and pay, and then have some supplemented money that comes from the EDD and unemployment insurance. But in many ways, it's a program that works best in normal times, where you are suffering a crisis and you need to make an announcement to your staff and say, look, hours are being reduced. We've got this plan that we've worked out with the state, and they're going to be helping some of you with your payments. With what's going on right now, the hoops that you have to kind of jump through with the work share, and the fact that you need to have like a liaison contact with the department, and the fact they're getting just swarmed with calls, makes it very difficult to set up a work share plan in a timely fashion. And so the best way to communicate to your employees is just tell them, look, hours are being reduced, and some of you may be eligible for supplemental unemployment insurance benefits, even though you're still working, and we encourage you to apply right away. Because that's just gonna be faster for the employees. So at a practical level, work share is an interesting idea in the abstract, but not so much right now in the crisis.
So we have someone here who is on furlough and has taken in a senior mother home from a senior center, and they're wondering if they're entitled to any money from the employer.
Not that I'm aware of, not on any of the regulations. I mean, if you're caring for somebody who is actually sick, then there might be leave benefits that are available under the Family First Coronavirus Response Act. But the significant sort of protections like the paid FMLA is just for childcare. It's not for senior dependent care. So nothing has really been created especially for that yet.
Okay.
I have a question.
Marcos, do you have another question?
Yeah.
Go ahead.
This is kind of a question to all the architects. With respect to employee efficiency and morale, have you guys found anything that's worked well? Because we found that some employees work well at home and others are kind of falling apart. So I was curious if you guys had any recommendations.
We'll let people chat that question in. But if that's something that interests people as well, to talk a little bit about how to boost morale at home while working, we're always looking for ideas for more our virtual forums. So please always send your ideas to me.
I would just say that a pizza party at the office is probably a bad idea.
Let's see here. From Tom Clark, and again, if you guys want to jump in on the call, please do once I announce your name. If an exempt employee can only work half-time due to childcare responsibilities, is FMLA applicable for hours not working?
That's an interesting one, because standard FMLA, which is unpaid, can be taken in small increments. So if somebody's got like a 2-hour doctor appointment, they can use FMLA leave for that. Say this is a protected doctor's appointment that I'm going to. And then with the new regulations that came out, we said, okay, are the old FMLA rules going to apply to this? And the Department of Labor issued regulations that said, basically, work it out. That was their recommendation, that employers and employees are strongly encouraged to work out how FMLA under the Federal Families Coronavirus Response Act is going to be handled, and if people can take them in increments, like half-day increments for these type of childcare type things. So the regulations don't say you're required to do it. Don't say you're not required to do it. It just says we strongly encourage you to work something out with your employee as it comes to that, which is somewhat frustrating, because what we want to hear from the federal agency that could make us, be liable in a lawsuit is some clarity on what I have to do here. But hopefully you can just work something out. I would encourage you to allow the FMLA to apply. However, you did note an exempt employee can only work half-time. So for an exempt employee, if somebody's being paid a salary, then they get paid if they do a little bit of work a day or if they do, a lot of work in a day. So if somebody's saying, well, I can work for the afternoon, but then I have to take care of the kids in the morning, so I can't work in the mornings, then under a salary regimen, you're still obligated to pay them their full salary. So what I would recommend is to have a discussion with the employee, and if the employee is saying, I can only work 5 hours a day now, roughly, that's going to be my average, then you should probably work out something with a reduced salary that keeps this in mind, because even the paid FMLA requirements under the Act, it's a fairly small amount per day, and so their salary, even if you said, well, we'll pay you FMLA amounts, it might be lower than that anyway. So my advice, if you're dealing with an exempt employee, is to renegotiate the pay package pending the crisis, rather than try to make some sort of hybrid of treating because if you start treating half their day as this FMLA pay and half their day is not, you're treating them like an hourly worker, because you're changing the way their rate of pay is depending on what hour of the day is.
So we just have 2 other questions here, and if you're okay, we'll answer them and then wrap it up. So this one, she summarized at the bottom, and again, Suzanne, if you want to elaborate more, is it okay for team members without kids to be treated differently from those with younger kids? And you can kind of see what she's going at before that.
Right. I mean, yes, in a way. We're all scrambling to try to work things out in this sort of in-between times that we're stuck in right now, with people working from home. And it seems like most employers are recognizing that if you've got children that you're taking care of because schools are closed, it's impacting the way that you're typically working. And so if you've got somebody who is working from home, doesn't have dependent obligations, and is saying, well, yeah, I'm working from home, but it's just kind of stressful, so I'd rather just work like 5 hours a day. You can certainly be harder on somebody with that reasoning than somebody saying, I can only work 5 hours a day because I've got 3 children under the age of 6 that I'm trying to corral, and I work the morning shift and my significant other works the afternoon shift. So, you're not supposed to discriminate against people based on, the existence of their families or things of that nature, but it's different when you're saying, I'm making exceptions because of people's actual circumstances and the circumstances they have to deal with in a home working environment, versus just because of, I like people with families versus I don't like people who don't have kids. That's discriminating based on just characteristics, but making exceptions for people because of circumstances is different.
Okay, so just one last question. What if an employee does not want to return to the office because they just don't feel safe?
Well, I touched on this with some of my slides, but if they are either exempt or, we hit May 15th and the stay-at-home order gets relaxed, for example, and somebody says, well, I still don't feel comfortable being at work. Cal-OSHA has and federal OSHA has safety requirements that are out there that if somebody is in, imminent peril, they're allowed to refuse to show up or refuse to perform an action. But there has to be, some identifiable risk, and just saying, well, I know that there's a disease that's generally out and about and I don't want to catch it is not specific enough. So there have to be, I feel like there's people that I'm working with that appear to me to have symptoms and nobody's asking them to stay home. That would be justifiable. But if somebody just says, I don't feel like coming back into the office once the call is made to return, I would say that in the immediate future, if they are still able to work remotely, probably just best to accommodate them temporarily. But note, this is a temporary accommodation. We're not sure that your concerns are fully justifiable, but just you know, in essence, that you're going to humor them for a little while, but that this is, you know, not something that we expect can be maintained indefinitely, so that they're on notice they're going to need to be coming back. And if that's not working out, or you cannot have them work remote, or the work remote hasn't been working out, you may discipline them, and you can tell them, well, you know, we need people who are coming to the office, we need people who are going out into the field, anything like that. And, you know, if you're not able to be that person, and that's who we hired you to be, then, you know, we're going to either put you on a furlough or unpaid leave of absence, or we're going to have to lay you off until you feel like you can come back and do the job.
Thank you, Ryan. I think that'll conclude the Q&A portion. I'd like to give it back to Carlo.
Ryan, thank you so very much, and thank everybody for your time tonight. I hope you find this useful. As Corinne said, please make sure you send us your requests for topics to discuss at these town hall meetings in the future. In fact, we're prepping the next couple of ones. The first one about employment and unemployment from a different point of view, with a headhunter and an employment agency. And another one talking about issues of equity in the time of COVID-19. So you all stay healthy. Corinne, you can close it now. Thank you very much.
Okay, I just want to say a big thank you to Ryan.